Welcome to the ProSocial Workers Podcast, the place where social work meets diversity, dialogue, and ethical practice. Here we offer courses that promote viewpoint and political diversity while fostering human connection. And the best part? Our content is completely free to access. For professional social workers and interested others, we provide the option to earn continuing education credits with a simple fee after listening to our episodes. Go to prosocialworkers.com to learn more. Together, we'll explore how to truly put the social back into social work. So tune in, get inspired, and join us on this journey towards a more inclusive and connected future.
Welcome to the ProSocial Podcast, sponsored by ProSocial Workers, a subsidiary of the Institute for Liberal Values. Our mission is to strengthen viewpoint diversity in social work education and practice. We seek to open space for thoughtful dialogue, intellectual humility, and a fuller understanding of the people in the communities that we serve. I'm Matt Watson. I'm the Executive Director of ProSocial Workers, and I'm joined today by my co-founder, Xander Kaag, the 2020 National Association of Social Workers Social Worker of the Year, along with our senior scholar, Dr. Nafisa Alam, an award-winning professor and founder of Heterodox Social Work within Heterodox Academy. In today's episode, we're taking a closer look at Childs versus Salazar, a significant case argued before the United States Supreme Court in October of 2025. The case centers on whether states may restrict certain types of conversations between licensed counselors and minors, raising important questions about professional speech, client autonomy, and self-determination, and the boundaries of state regulation in therapeutic settings. We'll explore the background of the case, the issues presented to the court, and the potential implications for counseling and social work in the broader landscape of helping professions. And each of us have had a chance to review and listen to the oral arguments. Listeners, you as our audience can find the oral arguments on YouTube, or transcripts are also available in the public domain. I would encourage you to listen to it. It's a fascinating case and a fascinating question and dialogue that I think we'll have today. Xander, you've offered some thoughts before on this. I'd be interested if you wouldn't mind kind of sharing your initial impressions.
Yeah, thanks, Matt. Well, just to nutshell it a little bit about the case, this is a clinical, right? This is a licensed therapist in the state of Colorado who has not been cited or charged, or nobody has indicated that she has been engaged in conversion therapy, but she took issue with the law as written, but it hadn't been applied to her. So I find that really interesting, maybe trying to get ahead of it. And part of it is based on what she believes are a few things, like the autonomy of independently licensed clinicians, in particular clinicians who have a religious belief system, and it's a part of the kind of work that they do. I think a lot of people don't really understand the work that social workers do in the context that we work in, the schools that we go to. I've run into this issue where people say religion shouldn't come into social work, and then they don't realize that Catholic and Baptist and LDS universities have BSW and MSW programs, that social workers work in churches. They work for organizations like Catholic Charities and Lutheran Services and the LDS Family Services and Jewish Family Services. Perhaps there's similar kinds of programs and services available for Muslim families and Hindu families, right? So we are being educated in religiously affiliated colleges and universities. We are working in settings that are predominantly religious or have like a church or an organization, a nonprofit that is started by a church. So to me, it's not a good argument, right? Because as social workers, we started in the church, right? That's the origin of our profession, going back over to England, right? We started in the churches. So with that said, part of what's going on too is that you have a law in Colorado, and then you have the NASW, or National Association of Social Workers, Code of Ethics. And so sometimes ethics and law can be in conflict with each other. And so who makes the decisions, right? Because we're bound by laws, but we're also bound by ethics. But I think the punishment is harsher if we break the law than if we violate an ethical code. And we can lose our license if we violate an ethical code and we're found to have done that in a intentional kind of way. Otherwise, there's different kinds of punishments. And conversion therapy, at least of minors, I think is something that's not allowed in many, many states. So, there's a lot of things that are involved in this. It's not just one clinician and one state. This is a really broad issue. The way that codes of ethics are interpreted is diverse. You can't really say there's only one way to interpret a code of ethic. And you also can't say there's only one way to interpret a law. That's why lawyers argue law in the courts and judges interpret law, and it's based on the particular frame that they take in how they interpret law. And I don't know all the fancy language for it, but I know that there's people who are very focused on, the constitutionality of a law or the historical underpinning of what did they mean when they first wrote the law. Right? And then there are people who are looking at it in the contemporary, right, in the current day. And so we're dealing with a newer law and a fairly new code of ethics. But conversion therapy is not a new topic. That's been around for a long time. Some people might know it as reparative therapy. And historically, what this practice was attempts to alter sexual orientation. And sometimes it was just talk therapy, but other times there were other interventions that were deployed, like hooking electrodes up to genitals and having people watch pornographic images, having people, that's bad, but I think kind of not worse, but maybe grosser is having people either talk about or describe same-sex relations while smelling rotten meat, right? So that the disgust instinct or impulse that we have in our brain gets tied to something that a person is feeling is a natural inclination or desire for them. Right. Mm-hmm. So it's a way to say you're going to experience something really negative when you have a thought or a desire because your mind is going to put these things together, sort of like Pavlov's dog with the ring the bell and they salivate. Right. So this is an unfortunate thing for people to be forced into.
Right.
What's really interesting, though, is that some people as adults, have voluntarily engaged in conversion therapy, or at least talk therapy to undo their homosexuality. That's not something I would have ever done or would ever do, but I believe in the agency of clients. And I believe, as the NASW does, that we need to be client-centered in our practices, or at least that's one frame, right? It's not the only frame. There's many frames. And this is another thing of it. We all have different intervention models. We all have different theoretical orientations. And so what ends up happening is people are arguing from their particular point of view, the way they do therapy, the way they want people to experience therapy. And they think everybody should take up that exact same position. And they should want the same thing for their clients, and they should want to deliver their clinical services in the exact same way. And that's just ideology, right? That's trying to force people to convert to a religion or force people to take on a belief system that they don't believe in, like a cult might do. Mm-hmm. And so I don't think that that's what therapy is supposed to be. Therapy is not supposed to be about convincing other people. We're supposed to meet people where they are. It's what they want. It's not what we want for them. And I think that's difficult for therapists, especially now when people are saying that the therapy room is where we should be practicing activism. And people are being trained in some MSW programs to be activists in the sessions with their clients. And so I think this is a big issue about this law in Colorado and this clinician in particular in Colorado, but this is a national thing and it's touching on so many third rails about ideology, about clinical practice, about self-efficacy and agency and being client-centered. So that's sort of the way I've been putting it together in my brain.
Great.
But also it's not based on me either. Yeah. Right. We all three are probably close. Right. We're probably close in our thoughts on this, but we're not exact. So that's
Exactly.
what we're going to be talking about.
So, Nafis, talk a little bit about that. As an educator, what's the difference between educating someone towards ethical practice and social work and educating somebody to become an activist? Can you kind of share your thoughts on the difference there?
Yeah, well, the activist, it assumes an ideological position and sort of answers the question before the questions are asked. Whereas the educational process is more about asking the questions and then the answers be whatever they may be. And so, one of the things about activist scholars, as they are called, calls into question whether or not they're so ideologically motivated that they're unable to see the diverse viewpoints that might exist within their own clients. When we talk about mental health, yes, we're talking about the practitioners, but at the center are the clients. The clients will inevitably be diverse, whether that's racial, whether that's gender, sexuality, whether that's socioeconomic status. And so activist scholars would sort of have that answer going in and not meet the client where they're at, rather attempt to fit the client into a pre-existing box. Very negative outlook of activist scholars there that I've put forth, but in order to counterpoint myself, it is efficient. We have to admit how efficient it is to go in and think of a client as like, all right, this is a brown male immigrant, for example, if I'm speaking of myself. And yes, most brown male immigrants have a particular experience that not most, but many do. And so it would be efficient to just assume that every brown male immigrant has had the same experience and just go from brown male immigrant to brown male immigrant to brown male immigrant and so on and so forth. So there's an efficiency factor there. But then, of course, I call into question, is mental health about efficiency or is it about effectiveness? And in that regard, in order to be effective, you truly need to meet the client where they're at, right? However, caseloads and workloads are through the roof. The turnover rate, particularly in social work, I know we're talking broadly about mental health here today, but if we can talk specifically about social work, and I'm sure it's true for other professions as well, there's a lot of turnover and there's a lot of stress that accompanies that turnover. And so can we really blame many social workers and many social work organizations, many mental health organizations for talking the talk when it comes to effectiveness, but then when the cameras are off and no one's taking notes, they operate on the basis of efficiency. So there's a practicality to that. And I think that practicality shows up sometimes in how codes of ethics are interpreted by universities and by social work organizations or mental health organizations. For our listeners and our viewers, anytime I say social work, please assume mental health because I'm so used to using social work. I think in order to properly have this discussion, we need to talk about the practical benefits of taking an efficiency approach. And the impactful benefits of taking an effectiveness approach.
Well, and sometimes efficiencies are things like bias or stereotypes and those kinds of things. It was interesting to see how in the Childs arguments that there seemed to be a conflation between what Ms. Childs was talking about in terms of her own practice and conversion therapy, or things that Xander was just describing. And what is highlighted in the NASW Code of Ethics in sections 2.01 that there needs to be respect for different individuals, groups, classes of people based on race, ethnicity, national origin, color, sex, sexual orientation, gender identity or expression, age, marital status, political belief, religion, immigration status, or mental or physical ability. Each of those populations need to be respected, regardless of what our stereotypes might be or what the efficiencies in our mind or our brain might be. And so slowing things down a little bit, that's what we hope to do today, is unpack this a little bit and slow it down and look at from a mental health practitioner lens, what might be the legal and ethical implications of this. In 4.02 of the Code of Ethics, it talks about avoiding discrimination based on those same identity markers. And then in 6.04, it talks specifically about preventing and eliminating the domination of or exploitation and discrimination against any person, group, or class based on those same identity markers. So the questions, some central questions that come up today are, I really like the way that it's been framed, Xander, in terms of what do the ethics say, but also, how do we be careful that we don't take such an efficient activist approach that as social workers we assume, or that the state should assume, that any of those identity markers have priority over the other. And perhaps the central question is, what do you do when when a person's identity markers may come in conflict with each other? Is it appropriate to allow an individual to create their own hierarchy of those identity markers, and which of their identities do they want to be the priority, rather than assuming that any one of those things is their primary identity? What does that look like? And so I think we can take a look at Miss Childs and recognize that although she's coming from a particular, or it seems to be that she's coming from this from a particular perspective, you don't have to agree with Miss Childs' beliefs or perspectives to see a broader concern about imposing or taking an activist approach in the therapy room. We need to be mindful of that our services, that professional services, focus first on the individual, and we're trying to address their particular needs, preferences, and self-determined goals. Any thoughts, follow up on that?
Yeah, I mean, I think what ends up happening is when arguments are being made, right, by lawyers or, whomever, right, the minister at the pulpit, like when you're trying to persuade somebody and you're making arguments, you're going to use language that pulls on particular strings, right, heartstrings or the mind string or, whatever it is. And so the way it's being argued from the state perspective in this case is that we want to prevent harm. And so, if you don't agree with us, then you want to harm people and you're okay with people being harmed, right? So they're framing it in a way of, we just want to prevent harm. And this lady, is going to be harming a bunch of people, a bunch of children. There's also the perspective that there's not a lot of disagreement in our professional mental health fields that these coercive efforts to change somebody's sexual orientation or gender identity are not effective, right? Like that's basically known. So they keep bringing it back to this thing. She wants to do conversion therapy. That's conversion therapy. And so they're conflating the exploration of identity with coercion out of the identity. There's this particular argument, and I've heard it many times from many different people in many different settings. If you talk about a basic therapeutic practice of exploring people's ideas and their thoughts, right? That's what we do. We explore. But when it comes to sexual orientation and gender identity in particular, you're not allowed to do that. You're being coercive. You're immediately assumed to be biased, prejudiced, discriminatory, that you're trying to change a person against their will. But what ends up happening is then we'll get like mandates from courts that then are, I think, part of the argument from the other side, right, is now these legal judgments, these legal mandates are going to replace clinical judgment, right? And we've gone to school, we've done thousands of hours of internship, we've taken a 4-hour exam, we're licensed by our boards, and now you're saying, oh, but in this area, we're going to take back some of that independence. We're going to take back some of that because we need to protect, these people. And again, I mentioned earlier about how some people as adults elect to go into therapy because they are struggling. They do have a distress with their sexual orientation and gender identity. And even if it's all external, even if it's their faith, even if it's their family, it doesn't matter. They're the client. They're having the struggle. And so we might say, I might say, well, let's teach you how to navigate all that distress and adapt and keep being you. And who cares what your faith and your family say? But that might not be what the client wants. The client wants to be all in with family and faith. And so how do we help them with that? And not all therapists are going to be capable of doing that. And so I think that's when you hand people off. We have to know what our limits are. And so these are not simple things. We're going to be dealing with clients who are diverse politically, socioeconomically, racially, ethnically, in sexual orientation and sex and everything. right? And I remember back in the 2020 period that there were I remember hearing social workers not talking but like posting about how if somebody came into the session with a MAGA hat, they'd like make them take it off or kick them out. And it's like, yeah, but you're forcing them to walk into an office that has a pride flag on the wall, right? So these are things we have to figure out as a profession. Like, how are we going to work with different people, and how are we going to be able to have a conversation with people if one side is posing the conversation in their ideological frame, and then you've got another group that's posing it in their ideological frame? I think one of the benefit of the three of us is that whether we have an ideological frame or not, we are open to hearing other people's frames. And as Nafis demonstrated just a moment ago in doing the counterpoint, being able to argue even from the other perspective. And I think that's kind of what's missing. Like, I think this case in particular is a therapist who wasn't found guilty of anything going up a system that decided that just the type of therapy it does and the type of therapist she is potentially already harmful. Like, maybe she shouldn't even have a license. And nobody said that, but I think that's kind of the frames that we're dealing with. And again, these are laws and ethics, and they're not set in stone. And that's really difficult for people. I have no idea how this is going to come out. Is this going to be another cake baker thing where the Supreme Court's going to rule on the side of the individual, right, as the professional, to practice as they see fit, especially with religious freedom? Like, what? Or is it going to be law and ethics? And are the ethics cut and dry, black and white? They are not. They are not.
I think that what makes this, it's similar. A case in Colorado goes to the Supreme Court around, issues of religious liberty and so forth. But there's a difference in that cake baking is not a regulated profession. And social work, mental health practice is a regulated profession. And that presents a little bit of an interesting perspective as well, in that should mental health practice be treated the same as medical practice? Are they the same? And in some ways, there are similarities, but there are significant differences. You know what I'm talking about? Where, ironically, it was the medicalization of homosexuality, or the diagnostic label that suggested that it was pathology up until 1973, where, our own profession created a situation where sexual orientation was pathologized. And even today, as we address gender dysphoria or a transgender identity, issues of transgender identity, to the degree that we adopt the medical model that pathologizes, that is a different approach than suggesting, okay, as an individual, you have your own identity where your own identities are experiencing a dialectic, where you are experiencing a conflict between your religious faith, family, social needs, and then your sexual or gender identity needs. To the degree that we invoke the medical model, it seems to be that has created its own problems, not just for the LGBTQ plus identities, but also for the broader culture, in seeing it through that similar lens. And you could see how Justice Jackson, throughout the questioning, kind of adopted that perspective. A lot of her questions were based in that perspective. Towards the end, she seemed to adapt a little bit and recognize that the medical model may not be the only way with which this may be viewed, looking at this from a person-centered, personal values model rather than a medical model that's pathologizing and creating, in many ways, a hostile environment for these different identity markers. Where in that particular context, you can see why there's interest in protecting someone from the harm that may come from creating, a pathologized identity.
I'm curious, either of you, but definitely Nafis, just because of the sort of the academic background and the teaching on these topics, what you would think about this. So, we've talked in previous episodes about the difference between like a critical social justice and a liberal or classical social justice. And it got me thinking about when we talk about conversion or conversion therapy, like would a mental health provider who has the critical social justice framework that informs their services, who had a client that came into them that was maybe a politically conservative person who has is very much a person of faith, would they consider it conversion therapy if they put a lot of attention on trying to steer that client away from being politically conservative and religiously faithful, right? I mean, like this can't be just a one-way street, right?
Yeah, I think that's the issue at hand, is that there's so many examples that go in all these different directions, right? So here we're talking about conversion therapy, a conversion being in reference to the application of religious philosophy in a therapeutic environment. And so that's what this case is about. But an analogy would be where if you were to be a social worker in a religious organization, foster care agency, let's say, and you have a 15, 16-year-old girl who comes to you and says, I'm pregnant, what are my options? Then that religious organization, religious agency might say, we do not talk about alternatives to pregnancy outside of adoption and parenting classes and things like that. And so if if the ruling rather for this case turns out to be against Childs and in favor of organizational mandates, then does that mean that religious social work agencies will now have the legal precedence to say none of our social workers will ever speak to our clients about alternatives to pregnancy because this is the Pandora's box you open up, right? Are you building the weapon that will be used against you one day? And so you're right, Xander, in that this isn't something, cases of this magnitude aren't just about the two parties involved or the groups of parties involved. It's about the social impact and the legal impact that moves forward. And so I'm certain, I wouldn't know this for sure, but I'm certain there are social work agencies watching this with a close eye and thinking, if the ruling is in favor of the profession being able to mandate what the professionals are able to and not able to discuss, then this could be used as leverage for organizations to apply that to their own bylaws. Why would laws be different from bylaws? Why would federal and state laws be different from organizational bylaws? Now, obviously, it wouldn't result in an arrest, but you would have grounds for termination, and termination sticks with you on your background check, on your record. So in many ways, it's its own kind of incarceration.
Yeah. I mean, it's like the free speech thing. It's like, well, it's free speech until I say it's hate speech. And it's like, but that's exactly why we have free speech in the United States, because it allows people to say hateful things. Yeah. Abhorrent things, ugly things within there's certain boundaries there, right? Legally. But it's like I don't think it's a smart thing to do to go this route of trying to shut everything down that doesn't adhere to a political or an ideological point of view, because that's a very short-sighted way of looking at things, because they're going to find themselves people that are in support of this or that on the other side of the issue, and they're going to wish that they had more room to operate. They're not going to like the law coming down on them, and it's going to be like, well, this is the precedent that was set.
I think society tends to lack that kind of foresight, and maybe so do we. It's one of those things where we think about the moment, at hand in isolation, in a vacuum, and then only years or maybe decades down the road do we realize, oh, wow, we really messed up, and this might fall into that same category. But I think I'm happy that we're talking about this, because it isn't a one-way street. We're talking about a legal case that has ramifications throughout for many people and many parties who are not even involved with the case. And so what happens if an organization is favored. An organization's or a profession's code of ethics is essentially ruled to be of higher value than a individual professional's code of ethics. I mean, that's what's at hand here. Would you agree? I mean, once the ruling is whatever it is, we're either going to come back to the table and say, we've realized that the professional is prioritized above the profession, or the profession is prioritized above the professional. That's what, in my simple, two brain cells here, is how I'm seeing this. And so, once a ruling is made, it's going to change the way or validate the way that I see, what is prioritized above what. Now, if the professional is the victor in this ruling, then that kind of calls into question another thing, which is like, does that diminish the value of the profession if the profession itself can be interpreted in so many different ways, if the profession itself is subject to the interpretation of the professional, and thus social work is whatever the social worker says it is. Mental health is whatever the mental health specialist says it is. And that's not exactly true either. And so a ruling is binary. You win or you lose. But the ramifications from that are way more nuanced. And I think initially, at least for a few months, maybe to a few years, I think society is going to see that ruling as too much of a binary before we get to the nuance.
I think it's a great point, Nafis, because if the ruling is that the profession determines the law, that is essentially what Colorado is arguing, that their rational review standard should apply to this law rather than strict scrutiny. And what that means is rational review is the lowest level of scrutiny that's applied. Whereas, Childs is suggesting that strict scrutiny should apply. So rational basis review is a judicial test applied when courts examine whether a statute or government action is constitutional. It asks whether the law has a legitimate state interest and whether the means chosen are reasonably connected to achieving that interest. And so it's applied to cases where there are no fundamental rights, like speech, privacy, religion, assembly, petitioning the government, or suspect classifications like race or religion are involved. So, rational review is typically used for economic regulations, social welfare policies, and so forth. But when you apply strict scrutiny is different, where we're saying there's a difference between what the profession is saying and what the law actually is. And it would create greater differentiation between this. And as a social worker, I'm not sure that I want to come to believe that my way of thinking and believing is the best way for everyone. Mm-hmm. Or that the things that my profession has come to believe, or the National Association of Social Workers, that the course that they choose to pursue or the political agenda that they have is good for everyone. Because I think that individual rights matter and that strict scrutiny should apply to an individual's rights to govern their lives, how they would like to have their lives governed, to have confidential conversations, personal conversations, for someone to be able to explore at length to the degree that I would like them to as a consumer, not necessarily speaking as a therapist now, but I would like as a consumer of mental health therapy to not have a therapist who is limited in what they can say or what they can't say, or who is worried that if I say something, this could be used against me in the future. And so what options does that have? Well, if you're worried about that as a professional, and this was brought up in the arguments, you could go be a coach. Do you realize that I'm not speaking of all coaches here, but coaches don't require any education, any supervised practice, any work to create a specialized, unique qualification or credential.
Yeah, it's an unregulated field.
Exactly. And many coaches, not all, but many coaches are former professionals who've had their license is challenged and they got tired of having to practice within the parameters of their profession. And so they simply went to becoming coaches. And thus, we have a professional dilemma in front of us. Do people who have conflicting identity markers or conflicting challenges or different dialectics in their life, are they better served by some degree of oversight and regulation, or no oversight and regulation, no ethics, or a profession that suggests that self-determination is appropriate and that there are parameters around what the practices of therapists? In many ways, it's trying to find, I think, the Goldilocks approach. What's too hot, what's too cold, what's just right, what's too hard, what's too soft, what's just right. And pluralism and things that honor self-determination, I think, is what I hope the court ends on, where I hope that they land, if I can just disclose my own bias here as a pluralistic pro-social worker.
Absolutely. While you were talking, Matt, I had this idea come into my head that oftentimes I think, just in my engagement with social workers, that there's this underlying assumption that some of them have, which is, everyone would choose what I choose if they just knew it was the right choice. Like I know it's the right choice, right? There is kind of that underlying assumption. Somehow they didn't either get the lecture or the class on, self-determination, and it's interesting, but it makes me immediately then jump in my mind to other topics that we've talked about on previous episodes about we've talked within like the critical lens or the framework. We've talked about one of the influences on that is queer theory, right? And with queer theory, I'm not going to give it the academic description because I don't actually remember it. It's been a long time since I've looked at it in that way. But the way I make sense of it in my mind is it's about removing lines and boundaries and limits, right? It's about delegitimizing things like courts and codes of ethics and institutions like marriage, right? And so laws. And yet at the same time, what I find really interesting is that often the people that have this as their background, like their ideological frame is coming from queer theory, and everybody would be just fine if they did what I told them to do because it's the right thing to do, are the same people that are using the courts and using the institutions and using the professional associations to enforce, what they want to be the way it is, right? It's like, well, if we're going to exist in the systems, then at least let's make sure the laws adhere to our, way of thinking. Or if we're going to be governed by institutions, well, then let's get in there and let's get those policies and statutes and regulations changed. And they've been quite successful, right? With the CSWE in particular, with the the accreditation. And what the BSW and MSW programs can teach and the sort of the philosophy behind it. And I'm sure we could probably talk a little bit about that because Nafis, you're way into that piece of what's going on with CSWE. But it's just so interesting to me. I heard one of the ACLU lawyers, I won't mention them by name, was referred to once, and I don't think it was in the derogatory sense. I think they even said it of themselves, that they're an anti-constitution constitutional lawyer. So they went to college, law school, they did law internships or clerking or whatever they did. They took the bar exam, they got a job at the ACLU, they argue in courtrooms, but they're anti-constitution. Like that to me, I don't know if that's silly or frightening. Sure.
Or it might be brilliant, It might be, that leaning into viewpoint diversity, which by definition must include the viewpoint that viewpoint diversity itself is not to be prioritized.
Don't hate the play, I hate the game.
Exactly. Yeah, I think, this is the fallacy of credential and the fallacy of status is that, just because you've gotten a doctorate or run an organization or have a certain status within an accrediting body, you feel like, all right, so I was selected for a reason, and so I will take on that leadership role and speak for, essentially everyone. Maybe not, everyone necessarily, but maybe through consensus. And so, I, I think bodies of power do a poor job of self-reflection. And I wonder if that's by design. Absolute power corrupts absolutely. And so, when power goes unchecked, like in many of the accrediting bodies that exist in social work, there is only one organization, there's only one CS, there's only one NASW, there's only one ASWB. And so, not speaking ill of that, I'm just, calling it what it is, just being factual and objective. Would competition result in better outcomes if there was a competitor to CSWE and NASW and ASWB? And if that were the case, how would there be competition? Because the size that it is and the impact and power that it has, any attempt to build an organization that would be its competitor would be shut down by the CSWE because it controls accreditation. It would be able to control whether or not the competitor exists. And from a practical business standpoint, why would any business promote the existence of its competitor? Why would Nike promote Under Armour? It just wouldn't make any sense. If anything, Nike would go out of its way to make sure that Under Armour is not able to produce the products by maybe making a better product or making the products right before Under Armour drops theirs.
Well, I would like to respond to that question. When social work or therapy moves into the medical model or the legal lane or something, that's when we put ourselves in peril. When social work becomes politicized, then the politicians can shut down social work. And that is what we're seeing right now. We've seen it in different jurisdictions where where when ideologies are put forth into the academies are, and social work is being threatened as a profession by the Trump administration because it has moved away from the social into the political. So if we can stay in the social, individual, self-determined lane of the individual that honors their relationship, not just with themselves, but with others, where pluralism is what social work is ultimately about: relationships with self and others, relationships between politics and the broader society, therapy and the broader society. When it is depoliticized, we are much more likely to be able to survive strict scrutiny. We're much more likely to survive the ideological onslaught of different things that happen from time to time, so that there's not a political need to undo social work or the profession of social work. There are examples where, I've shared before in other podcasts, where, for example, the teaching of critical race theory resulted in politicians, removing funding from those schools because a particular ideology was put forth as the dominant ideology. If we can present alternatives, just as you have today, Nafis, and present that as one option, but it's not the only option. When we honor agency, self-determination of individuals, communities, and so forth, then we're more likely to maintain the credibility of our profession and what we do. As soon as we get politicized and we invite the state into the therapy room, we're in trouble. We're on thin ice.
And where this shows up a lot is, I'll go on the record and say I think conversion therapy harms people. I'm not arguing that people should be allowed to practice conversion therapy, right? But I don't think exploring identities is harmful, right? Necessarily. It can create distress, right? Cognitive dissonance, uncertainty, which are uncomfortable, but that doesn't mean they're harmful. But, states do have the duty to protect children, right? To protect their citizens. So, Colorado is arguing we have a duty to protect children from these coercive, harmful practices. And it's like, well, they're using the lens is more of a historical, coercive conversion therapy of primarily gay and lesbian people, so that, we have to separate out, practices from the 50s, 60s, 70s, and 80s from what's happening now, where maybe there's just identity confusion going on. There might be some cultural and religious conflict that clients are dealing with, even children, some developmental distress when they're thinking about like, all, on top of all these things of adjusting to going from being, a toddler to a child to an adolescent to a young adult. Now I've got this other stuff on top of it, like most people do. But now there's all these external pressures, and there's so much happening. I would think that social media is impacting this in a lot of ways. But this duty to protect is clear. But we can see already that the states are handling this very differently, right? So let's say in the state of California, where they have a majority Democrat, state house and Senate and governor, their duty to protect children who have maybe gender dysphoria or gender distress is to be pro-medical transition without parental consent, if need be, and even possibly punishing the parent by removal by Child Protective Services. Whereas you take a state like Florida, that's the complete opposite. It's majority, Republican in the House and Senate, and it's a Republican governor. And their duty to protect children is interpreted as not letting parents be the sole decision maker in conjunction with a medical provider that a child should medically transition because of the harms that can cause, right? So they've each decided, right? There's many, many states. I think there's maybe 27 or 28 states that have gone the way of Florida. So it is the majority of states that have gone the way of Florida, saying, no, people have to, these kids have to wait until they're a certain age. So this duty to protect is real, but it's being interpreted differently and applied differently. And I mean, one could ask, right, when things get up to the Supreme Court level, there are pros and cons to that. Because if this court, if they're able to do this in this case, make a decision that doesn't just impact Colorado, it also impacts Illinois and New York and California. Colorado will be responsible in some ways for that, because they sort of kept going and going with it all the way to that level. With like same-sex marriage, that made everything across the country change. So they, in a few of the cases recently, like say the middle schooler and the college student who were in sports, right? So the trans girl and the young trans woman that were wanting to compete in college and middle school sports. I don't think that decision has come out yet either, but is that only going to apply to those states, or is that going to be national? It's a big risk that they're taking, bringing this. Maybe it was Childs, her people, who kind of pushed it to this level, but it'll be really interesting to see how it falls, because absolutely we have to protect children. What does that mean?
Yeah. Well, the issue of protection is a really key element to this case. What is the state's responsibility to protect? Conversion therapy that involved aversive means, creating just unnecessary distress or ways of trying to get rid of it. I mean, it was shown to be ineffective in that how can you get rid of something that in your mind that you're naturally thinking about, or in your internal experience? How can you, so there were the aversive means, there were a lot of things about the conversion therapy that it's understandable. I think many people could understand and get behind that. The description of Child's attorney, Mr. Campbell, he stated, Ms. Childs helps clients with their goals to resolve gender dysphoria by getting comfortable with their body and realigning their identity with their sex. She also helps them if they're experiencing unwanted same-sex attraction, if that's their goal, to reduce it. And she helps them deal with issues of unwanted same-sex behavior. Now, that doesn't define identity, but if somebody wants to choose to identify themselves with their behavior or with experiences of attraction, as fluid or as dynamic as that may be, that's their right, but it's also their right not to. Would you agree with that?
Yeah, I think the argument would be in the counter, nobody would ever choose that if we lived in a society that didn't stigmatize same sex attraction or didn't try and, create barriers for, trans people,
Right.
right? So the
If
assumption
you
is
didn't
that
essentialize
nobody,
that, yeah.
yeah, nobody would actually want to do that. They're just trying to fit themselves into this heteronormative Christian, patriarchal right there, which is like they're just it's queer theory postmodernist gobbledygook that they're speaking. But I mean, I see the legitimacy of that.
Sure.
What we don't know is we actually don't know. We don't know if a person living in an ideal world where everything was full on, do as you please, if people still would say, I am uncomfortable with these desires. I want to do something about that. We really don't know.
Mm-hmm.
Like it's this idea that of course we know if we lived fully free and it was free everything, we could just do whatever we wanted and everything was okay, everybody would be that way. Everybody would be hedonistic and right, like pleasure seeking. And it's like, no, they wouldn't. But I can't know that actually. Maybe they would. That's what I find really interesting about this case. I really wish this case were brought by a therapist who had actually either been threatened with loss of their license or had actually lost it. Because since she hadn't, since she brought this just as a, I don't like it and it makes me, like, I don't know how I can practice, with this constraint, like in the back of my mind, because it gives more liberty for the state to keep hammering on this conversion therapy and harm and protect children. And there's nothing she can say to show like, but I haven't actually harmed a child. You haven't proved that I've harmed a child. I
Mm-hmm.
wish there was a bit more like meat on her bones, so to speak, of her arguments. I really do. I don't know if that'll hurt this case from her perspective or not,
Well,
but
it is impacting it because there were a lot of questions about standing. And does she have standing? Because she hasn't. So there are a number of ways that the case may go. They may remand it back to the lower courts once they've clarified a few things about which principles apply or don't apply and let the lower courts rule on it. But they also started to talk about how since this started to gain momentum, there were complaints that are being investigated right now.
about her.
Yeah, about her.
Well, see, what's really interesting is that, like somebody who's not a client of mine can't, well, they could send off a letter to the, Florida State Licensing Board
Mm-hmm.
saying that I've behaved in some way that's unethical. But if they're not an actual client of mine, it
Yeah.
doesn't have the same weight, right? They don't have standing.
Right.
They're not my client.
Right.
So a lot of times what happens, and this happened with Dr. Jordan Peterson, people who hadn't even seen him put in a bunch of complaints about him. And
Canada's
unfortunately, the Canadian Board of Psychologists or whatever they call it up there, they acted on those claims that came from non-clients.
Mm-hmm.
So she's doing it in the reverse.
Yeah, it's a good point, Xander. And this is a case that this is a point that was made in the case in the oral arguments that if you're trying to protect the population, malpractice law already takes care of that.
Mhm.
There are 4 elements of a malpractice claim. One is you have to have a duty. And so it's possible, and apparently who knows if it was just kind of the Jordan Peterson treatment to the board, that a lot of the population were just making complaints about Ms. Childs. We don't know if those were former clients or not, but you've got to have a duty, a professional duty to that particular. That's where, descriptions of services and informed consent come into play. If you've got that, and if you've established a duty to care, that's one level. Then you have to show a breach of that duty. that you weren't performing your duty to the client to look out for their best interests. Now, that could create some exposure to a client who does prioritize their family and their faith over their gender identity or other markers. If you go in and you pursue something that's contrary to their self-determined goals, you're also exposing yourself to a malpractice claim. The third is harm. So there's duty, breach, harm caused. You have to demonstrate that there was harm caused by that claim or the actions of the therapist. And then the fourth is causation, that there had to be causation between the counselor's duty and their breach of their duty and their actions and the harm that you incurred. And so it is tricky to win, to prevail in a malpractice claim, but it's possible. And those things protect both the public, but they also protect the professional. So the question of protection, it can cut both ways.
Mm-hmm. And it's good to keep that in mind.
Yeah, it really can. All right. Other thoughts on this case? Other things that you thought were essential or critical to know?
I think it's critical to know that from what I've read, the clients themselves wanted the services that were being provided. So it wasn't that the social worker was intentionally not meeting the client where they're at. They were meeting the client or the mental health person, professional. They were meeting the client where they're at, but the profession was limiting what the definition of at means. And so, obviously I'm not in the courtroom. I'm certainly not a lawyer, but when I think of that, that's a very important part of the case that seems more nuanced. And in many ways, perhaps you need to be a mental health professional like we are in order to notice that. But nowhere did I see that a client went in there not wanting the services that were being provided, and they were instead being provided forcefully. And so by the letter of the law, it would appear that the mental health professional was practicing the concept of meeting the client where they're at. The clients wanted help with what they were seeking services for. Now, the profession could decide that seeking help for such a topic is taboo, in which case, are we really going to be meeting the client where they're at? So there's a lot of consequences that are ahead. No matter how the ruling falls, there's going to be a lot of consequences.
Yeah, I jotted down some questions that I thought, for the listener. Some, these are just some implications that have come up with this case, which is like, how do we distinguish what is going in a harmful direction, right? If we're engaging in open-ended exploration, which a lot of us do, that's part of a lot of theoretical orientation intervention models, right? This open-ended exploration, if that's deemed somehow a component of a coercive relationship or model, right? And I think a bigger question for mental health specifically, and I think a critique of mental health from other more scientific, so to speak, professions is, can our professions as mental health professionals, can we follow scientific standards, or are we just always going to be dealing with an ideological conformity or an enforcement of ideology into our professions? Like how porous are we to these kinds of influences? And also, this idea of not causing harm or protection, right? To what degree do we hold protection of our clients while also engaging in really complex therapeutic relationships, right? People are coming to us, whether they're children, adolescents, young adults, older adults, with real complex lives, right? We're not necessarily talking about, as my MSW program professors often refer to it as, the worried well, right? We're not talking about people who are just sort of seeing a therapist to, have a place to vent every week or every 2 weeks. We're talking about people who are coming in with really complex situations. And identity formation is complex. It's not an easy thing. And there's all kinds of external pressures, and there's hormonal internal pressures, and there's family, and there's faith, and there's peers, and there's a lot going on. It's very complex. And I don't think we can reduce that complexity in any direction. It's just a matter of sitting with it. And in my experience, not a lot of people are comfortable with sitting in complexity. Distress is distressing, right? It's hard for people. And so they want to manage their own distress as a clinician by managing the distress of the client, by trying to tell them what would be in their best interest, because then they could feel really good about it and have, as often we hear within the trans community, they'll get a gender euphoria. And then the therapist can calm down because the client is experiencing a euphoric feeling, but that's not going to last. Real life is going to kick back in, and that euphoria is going to, is going to come back into a more complex place, and maybe the dysphoria will emerge again. And so you see this a lot in the studies that are done around what they would call like transgender youth. And most of them are very short-term focused, right? Whether it's therapeutic or surgical or whatever, medical interventions that are being done, they do follow up, but it's a few months later or maybe a year or two later. But they're not following up, at least in the United States, 5 years, 10 years, 20, 30 years later. Life is complex, right? So there's all kinds of conflicts that are going to be coming up: identity, religion, family, culture. There's conflicts. And we might be, as clinicians, we might be able to solve it for our clients here and now, but are we going to be there for them when it comes back up again in a different way, different context, in 5 years, 10 years, right? Are we kicking the can down the road to the next therapist and the next therapist who is approached by this client because we put frosting on a unbaked cake? You know what I mean?
Yeah, it is complex, Xander. Human life is complex. Humanity is complex. The society in which we live is complex. Social relationships are complex. There are an infinite number of factors that play into different things. And that's why self-determination is key to social work practice, because to the degree that you try to coerce belief, values, the more, the stronger you push, oftentimes the greater the resistance. Whereas if we can practice pluralism, tolerance, respect for individual rights, respect for individual identity, moving away from group identity or the suggestion that the only thing that matters is power, and this is about breaking down the systems of oppression, that as soon as we adopt that postmodern or critical mindset, we are engaging in or adopting a particular ideology. And so by honoring the complexities, that I believe is what has helped and what may continue to help mental health therapy as a profession, as a practice survive, rather than trying to create a state dictated or imposed ideology or hierarchy of identity and the things that matter. That said, we have to be mindful of unintended consequences. I'm not suggesting that the state should not be involved in regulatory practice. I do believe that there is a need for regulation of mental health practice. I do believe that there are things that are ethical or unethical. I also believe that there are things that are moral and immoral. I also believe that there are things that are legal and illegal. I'm not trying to break down or destroy the institutions that have over the years governed social work or mental health therapy practice, but I'm trying to, through this discussion and thinking this through myself, kind of find that zone that creates individual liberty, an individual's ability to decide what their priorities are and help them be well. And part of that wellness is relating to others. It is social, and help them recognize that whatever identity markers they choose, even though they may not choose some of the experiences, the world in which they were born into. There are a number of things that are not by choice, but there are things that they can choose in how to respond and how to react and how to prioritize the things that matter to them. That is ultimately what I think we want to do. Is that's why I think, the Constitution of the United States has survived as long as it has, because it does privilege individual rights and promotes pluralism.
I think it's probably the case that there are young people that are coming into therapy who have a lot of confusion around their gender because it's been made more complicated, right? It's not just, the language of everybody has a gender identity and they're like, oh, so then they have to figure that out. And then there's gender roles, and then there's gender expression, and there's all kinds of pressure, especially on boys, to not be toxically masculine, not to be aggressive and dominant, right? So I would imagine that there are young people who are going into therapy because they have a type of gender distress that might get labeled as gender dysphoria. And those kids are not the ones, they're not the same as the kids who are distressed from the external stuff, right? I think there's going to be kids who are having a type of gender distress or dysphoria from external stuff. And then there are going to be kids who are going to be having it internal because they're very confused with all of these words and labels and expectations of them. And, if the child who has gender dysphoria because they know themselves to be trans, right? We're supposed to trust that they know who they are. Then we're going to have to also trust that some of these kids also know who they're not, but they are confused, or they're getting either pressure from their peers because the desire to belong to their peer group is so strong that they're altering their mannerisms and their style of dress and the words they're using to call themselves. I remember when I was 19 years old, I'm almost 60, so this is a while back. I was 19 years old and I was hanging out with 3 friends over the course of a weekend. One was a young gay guy. We were all about the same age, and the other 2 were young lesbians, like I was at the time. And we got together about a month. We were sort of hanging out for some reason, and we didn't see each other for a couple of months. And when we got back together a couple of months later, because I think we were all just sort of like, oh, you're gay too? Oh, you're gay too? Like, we had never really talked about that up to that point. And the one guy, the gay guy, he went off to Palm Springs. This was Los Angeles, right? He went off to Palm Springs and experienced a weekend of, I'm just going to call it debauchery of, sex and drugs in Palm Springs at some sort of, gay resort or something. And all of a sudden, he was snapping his fingers. He was lisping. Right? He changed. I had known him for years. He changed the way he walked, the way he stood, the way he gestured, the way he spoke. He changed his attire. Everything about him changed after spending one weekend in Palm Springs at this resort with hundreds and hundreds of gay men. And I remember looking at him at one point and saying, "What are you doing? Like, we know you're gay. Like, you've never behaved this way before." And he said, well, I was suppressing it. It's like, you were suppressing a lisp. You were suppressing walking like a model on the catwalk. Like, he might have been suppressing his telling people he was gay, but not all of a sudden all these new mannerisms, right, and gestures. And so I think, if a 19-year-old is susceptible to that, well, surely a 10-year-old is, or a 13-year-old, right? With those kinds of pressures, some people like this mental health provider, they're going to see people that are in that camp. And those individuals, those young people, they wouldn't be well served by an activist, trans identified, therapist who wants to get them to, start showing up at protests, waving the trans flag. That could actually cause them harm, but they don't see it as that way. Right? So if they know who they are, then we have to respect and accept that they also know who they're not, or at least who they're not right now. Right? If we talk about gender is fluid, or we talk about gender being on a spectrum, or it's a journey, well, then we have to accept that this can be part of a person's gender journey too.
Mm-hmm.
The gender journey can't just go in all one direction.
Absolutely.
You know?
Well, and that was an argument that was made in the case. Justice Kagan specifically asked it, if I recall correctly. Is this symmetrical? Would this apply to someone that wants to change their sexuality or their gender identity from, a heterosexual to homosexual or bisexual or, cis to trans? Would it go in both directions? And is it neutral? Is there neutrality? And that was one, I think, if I recall correctly, the response was that the law only is enforced when dealing with identity, not necessarily behavior. So the argument was that this is innate, that sexual identity or gender identity is innate, immutable, and sacred and cannot be moved if it is trans or same-sex oriented.
I mean, I know the argument is born this way. I remember when there was that switch from sexual preference to sexual orientation, and then the argument went to like born this way. And I know that the trans community has borrowed a lot of that language for the way that we argue for having the same kinds of rights, because, well, if gay people are born that way, we're born that way too. But then things started showing up and they were like, well, I guess we better talk about this as a gender journey, right? It's very complex, but it's one thing to say it, right? People are born with a sexual orientation. I don't know that that's actually been proven. I do know that people feel a particular way in default, right? Mm-hmm. They're either exclusively, but mostly predominantly same-sex or opposite-sex attracted, and then people who are attracted to both sexes in varying degrees. Mm-hmm. Right? It was very rare, at least on the Kinsey scale, that there's an exclusively heterosexual and exclusively homosexual. Right. That's rare, right? Are we born with it? Is it innate? Is it all nature? Is there some nurture? I don't think that's been settled, but I get the question too, which is, well, what if there was a clinician that was trying to convince heterosexual clients or monogamous clients that they really should be polyamorous, mm-hmm. or that they should explore their bisexuality because they had just a tip on the scale towards not exclusively opposite sex attracted. Well, have you explored your bisexuality? Would that be considered a type of coercion? You really should be exploring that. I don't know if that's happening out in the world, but somebody could try and do it. Would the law hold them to the same? Would it hold up in that situation?
Yeah. Well, I think it was a hypothetical that came up. And in fairness to those who've been harmed by, a societal essentialization of their sexuality or their gender identity or their sexual orientation or their gender identity, while it's a hypothetical, it's not necessarily the same, because of the essentialization and the impact, the harms that have come through that essentialization have really only flowed in one direction.
Yeah, but we don't know what the future holds. What if the future is queer?
Well, that's a good point. And I think that's where it just goes to the principle of there are things that we know and there are things that we don't know. And of those things that we don't know, it comes down to one's personal values, to one's personal interests, and to be stereotyped regardless of the efficiencies, regardless of what someone would prefer. We have to be mindful that pluralism and respect for viewpoint diversity, respect for individual liberties, respect for freedom of speech, speech as embodied thought. The people get to believe and think how they want, and that we don't want to move towards an authoritarian world. We want to move towards a social world, and from a social worker's perspective, that is, I think, what we hope for and try to do. Okay, any final thoughts?
No, I think we did a good job of giving this topic a respectful and neutral review. Yeah, that's my final thought.
I'll just add that it's good to keep in mind that laws are two-directional or multi-directional. That when sex as a category was set aside as a legally protected group, I don't think people thought that one day men would use it. But sex discrimination is sex discrimination. It's not discrimination against women. It's men and women. And race is the same way. I would imagine that race as a category, people didn't conceive of the possibility that there would be discrimination against white people and white people would bring lawsuits. But they have been, they've brought them, and they've been successful. So this will go in the directions that it goes. And so that'll be the future.
Very good. Well, our perspective here is one that privileges viewpoint diversity. If listeners have different perspectives that you'd like to share with us, we seek different viewpoints and would welcome an opportunity to expand the conversation and the dialogue, and hope that you'll get in touch with us via our website. There's a contact us link, a way to get in touch with us, and we would hope to continue the conversation. The ruling on Childs versus Salazar will likely come out in June or sometimes late spring. And we'll continue this conversation and this dialogue in the review that we're giving it. Ultimately, we hope that this contributes to improved viewpoint diversity within social work and within our broader society. So thank you for joining us today.
Thank you.
Thank you.
Thank you for joining us on this episode of the ProSocial Workers podcast. We're grateful to our guests for sharing their insights, and to you, our listeners, for being part of this journey. If you'd like to earn continuing education credits, don't forget to visit our website at prosocialworkers.com, where you can register, pay a fee, complete a course evaluation, and take a quick quiz. We look forward to having you with us next time as we continue to explore how we can put the social back into social work.